If you've ever gotten a call from a debt collector, there's a very good chance, that at some point during that call, they broke the law. Not a gray area. Not a technicality. An actual violation of federal law that most people have no idea exists. By the end of this video, you'll know exactly what debt collectors are legally allowed to do, what crosses the line, and what to do the moment it happens, because most people just hang up and stay scared. You don't have to. Here's rule number 1. There's a federal law that limits how debt collectors can contact you, how often, what times, and what they're allowed to say. Most people have never read it. Most collectors are counting on that. They cannot call you before 8 a.m. or after 9 p.m. your local time. That's not a courtesy, it's the law. If a collector calls at 6 a.m., that's already a violation you can report. They cannot call you at work if you've told them even once, verbally, that your employer doesn't allow it. One sentence, and by law, they have to stop calling you there. They cannot threaten you with arrest. Ever. Debt collection is a civil matter, not a criminal one. Nobody goes to jail for an unpaid credit card or medical bill in this country. If a collector says the words arrest or warrant, that's a violation, full stop. They cannot discuss your debt with your family, your neighbors, or your coworkers. They're allowed to contact other people exactly once to try to locate you. That's it. If they call your mother a second time and mention what you owe, that's illegal. They cannot lie about the amount you owe, threaten to seize property they have no legal right to seize, or claim to be attorneys or government officials if they aren't. Here's the tool almost nobody uses, the written validation request. Within 5 days of first contact, a collector is required to send you a validation notice, proof of the debt, the original creditor, and the amount. If you send a written request disputing the debt within 30 days, they are legally required to stop all collection activity until they provide proof. Most collection agencies buy debt for pennies on the dollar and can't always produce clean documentation fast. A simple, calm, written dispute stops the calls immediately, often permanently. Here's what to do the moment a violation happens. Write down the date, the time, the phone number, and exactly what was said, word for word if you can. If it's a text or email, screenshot it. This documentation is what makes a complaint enforceable. Then file a complaint with your state attorney general's office and the Federal Consumer Protection Agency that oversees debt collection. These complaints are tracked, and repeat violations can lead to real penalties for the collection agency, not just an apology. And here's something most people don't realize: if a debt collector violates the law, you may be entitled to statutory damages, real money, sometimes without even having to prove financial harm, simply because the violation happened. Consumer attorneys often take these cases for free because the law allows them to collect fees from the collector, not from you. That flips the entire power dynamic. You're not powerless on that call. The law is very specifically written to protect you, most people just don't know it exists. 3 things to remember. Know the rules: no calls before 8 a.m. or after 9 p.m., no threats of arrest, no discussing your debt with others. Document everything the moment something crosses the line. And use a written validation request if you're not sure the debt is even accurate. Debt is stressful enough without collectors making it worse by breaking the law and betting you won't notice. Now you will. We track the financial traps that don't make headlines so you're never caught off guard. If this helped, subscribe. We post every day. I'll see you in the next one.